Hey, so in a recent video about ALJ hearings, we are going over the part of the hearing where the vocational expert is going to be asked hypotheticals. I had a hearing today. It was fabulous. Um, Better than I expected. I expected okay. I hoped for okay. I was hopeful for okay, but it was better than okay. Anyway, and it became clear to me at the hearing that it was going to be a better okay because, and this is not typical, the ALJ asked one hypothetical. One. So there was no question, by and large, as to what RFC he's going to be applying to my client, because he only asked the vocational expert about one residual functional capacity assessment with all the limitations described within. So, and that one included things that I already know vocationally provide for no jobs. That would be being off task more than 20% of a day, missing more than 2 days a month from work due to medical symptoms. Amongst the other, because when you go to the beginning of the hypothetical, they're talking about sedentary or light or whatever. Then they're talking about can the person be around hazardous machinery? Can they balance on scaffolds? Do they need a sit-stand option? How much can they use their hands? So while I might not have agreed with all of the other parts of the hypothetical, all the limitations, I thought some were easier than others, but I understood kind of where they were coming from because some might be improving in the near future. But anyway, so when I heard the very clearly disabling limitations added in there that I already know from years of doing this would be disabled, I knew it was good. So when you have one hypothetical, and again, this is more rare because I think oftentimes the judge isn't sure whether he's going to deny or award because they have to get through the rest of the evidence, which includes the testimony, which hasn't happened yet. And I think also they want to, once they hear the testimony, really go back and, you heard a couple of things. Is there anything in the record that supports that or refutes that? And they can come to a final determination for cases that might be close. And there is that multiple hypothetical situation, which is typical because that way they can include what they perceive as being the possible RFCs that might apply to the claimant. So when there's only one, it can be very bad because there are jobs that the vocational expert indicates are doable with that RFC. And then if the judge doesn't continue to go on and ask more limited hypotheticals after that, that's when the lawyer has to jump in and make sure those get in, or the claimant if you're unrepresented. So you got to figure out how to do that. But if there's one and it is all good and there's no other options, that's when you're almost at the point of singing. I always say I want to see the decision in writing, and that's true. But sometimes the judge will also put right on the record that I am deciding that you are disabled, or I'm giving you a favorable award, and then you pretty much know you're in. So anyway, one hypothetical, it usually spells the story. And so you kind of know what the result is going to be before you get the decision. Okay. Anyway, enough on that. It was a good day. Let's hope tomorrow is as good as today. All right. Bye now.